Hello, everyone, and welcome to another WBA Legal Compliance Corner. In the Compliance Corner video, to those of you who are new, we like to bring you an update on hot topics that we're seeing in the world of compliance from month to month. So in this edition, we have April, and we'll be updating you on what we have seen in the previous month. As with previous videos, what we like to do is we'll start with a summary in just a moment. And then as we go through each slide, we'll have some info on each topic. And you'll see that some topics are marked with an asterisk. That means that we have included a link to additional information for that topic in the description below, in the video description. So make sure to navigate down to that description and click on the link if you want more information on a particular topic. So what we have for April, we have a couple of CFPB items that we'll start with, including a supervisory highlights. We also have a publication that CFPB recently put on the Federal Register relating to a past circular that we'll cover. FinCEN also has some updates. As always, we like to include notices when they have an update on recent trends within the realm of financial crimes relating to some red flags on how to spot them, some SAR reporting instructions, as well as updated beneficial ownership information reporting FAQs, and a recent analysis regarding trends in elder financial exploitation. And we have some Department of Labor items. We have a revised overtime rule and retirement security rule. Then we'll wrap up with some FTC items, which includes an alert on scams involving student loan forgiveness and a rule banning non-compete clauses. We'll get started with our first slide of items, which is going to be our CFPB. So the first CFPB item we have is the Spring Supervisory Highlights edition of 2024. And so within this issue, there's a focus on inaccuracies in the credit reporting system. So CFPB focuses on issues both for credit reporting companies and furnishers of information. In both cases, the issues are really specific to rules regarding info resulting from alleged identity theft or human trafficking. And you can kind of see that summarized at the top of this slide here regarding those inaccuracies. And so specific to furnishers of information, CFPB has found that there's issues both with the FCRA and Regulation V requirements. More specifically, in terms of the requirements to update or correct information that was reported as incomplete or inaccurate. And CFPB has found, particularly with some auto loan furnishers who received identity theft reports at qualifying addresses, continued to furnish information that had been identified in that report before verifying that that information was correct. So that's the big takeaway here, is that if you're a furnisher of information, make sure that you understand your FCRA and Reg V obligations. Specifically, it might be worth considering taking a review of your policies with an eye out for making sure that those reports are accurate, and in particular, how you're responding to identity theft reports, knowing that there are specific requirements regarding information that relates to identity theft. Next item relates to circulars that were published in the Federal Register. So a bit of a background context for this. Last fall, CFPB published a circular that was related to using sample forms for adverse action, meaning specifically relating to the sample reasons for denial that CFPB has put out. And the issue at hand here is kind of a question, and CFPB presents it as a question. They say, in those situations where maybe those specific statements, those sample statements and those reasons for denial don't best describe the reason for adverse action, is it still okay to use those and rely on them and maybe select one that might seem like it's the closest? Or again, the idea being, can we just rely on these statements really in every situation? Specifically in the context of using artificial intelligence or complex credit models, maybe where there's predictive algorithms, for example, and those don't quite fit in maybe with what the sample reasons are doing. The answer CFPB gave is that, in short, no. Those samples can't be used where they don't accurately reflect the rationale, and that being the key, of course, because we need to give an accurate statement of reasons for denial. And those samples that CFPB gives, it's not an exhaustive list. It's just examples. They're a list of common scenarios and sample reasons for denial. If they don't encompass the rationale for the actual denial, then another reason must be given. So, if you're using those models, again, if you're using AI or those complex credit models, for example, if you are, make sure that you consider how you're providing your adverse action. And if you're using those samples, and how you're designing and using and giving your statement for specific reasons. CFPB did provide this along with some broader concerns regarding the use of information in terms of what's gathered and how. And this is on the models, right? So there's a broader conversation at hand here. Really, the issue specific to this is the use of the samples, but CFPB is kind of nodding and alleging to the bigger issue of use of these models as well, which we've talked about in the past. But the idea being use of predictive models, use of AI from a consumer harm and risk perspective, and how that information is gathered. So in that broader context, if you're using these models, we're thinking about it in the future, keep both those specific considerations in mind for how you're giving your adverse action and your statement of specific reasons, but not only how you're denying credit, but what you're obtaining it for and how you're using. And again, just in general, then, to take a step back for everyone, even if you're saying, well, I don't use those predictive models, and we do use those samples, but again, just from a very broad perspective, make sure your statement of specific reasons for denials are accurate and is specific to the reason for why the credit was denied. The last item we have here is deceptive marketing practices about the speed and cost of sending remittance transfer. So this is specific to remittance transfer, and not sure how many would fall under this last, would fall under a remittance transfer provider, given that most in Wisconsin don't necessarily do enough in a year to be considered a remittance transfer provider, but there may be some. And considering that there is still a valid concern here, because for anyone who can make remittance transfers, we want to consider UDAP. And that's what this is getting at. Concern being for UDAP, how remittance transfers are advertised. So even if you're not necessarily a remittance transfer provider for purposes of the rule, and by that definition, which would trigger certain requirements, if you're advertising for remittance transfers or marketing for them in some way, this is still something to keep in mind. And so CFPB has outlined some specific scenarios that could be considered misleading or deceptive about marketing the speed and cost of sending a remittance transfer. For example, if you're representing that remittance transfers are going to be delivered within a certain time frame, right, a certain period of days, or how fast, right, it's actually going to get sent, but it's actually going to take longer, or marketing them as no fee when there is, in fact, a fee, or using language such as free, right, free remittance transfers where they are, in fact, not free. Or maybe if there's a promotional rate, promotional fees, without providing clarification in the advertisement for when or how to actually obtain those promotional offerings. So again, the takeaway here being that if you do provide remittance transfers, regardless of how many, you're advertising for them or marketing them in some way, make sure that you consider UDAP, just as you would for any other services. Moving on to the next slide here, and some FinCEN releases that we have. The first one being a notice on counterfeit passport cards for purposes of ID theft and fraud. And of course, just what we need, we're thinking another fraud tactic to be aware of. But we know that banks in Wisconsin are vigilant, and this is just a continuing trend that we need to stay on top of where the fraudsters' efforts are. And FinCEN is remaining vigilant as well. And these notices are very helpful, right? They're quite comprehensive on the information that they have in there to support your effort in continuing to combat fraud where we see it. And so here, the notice is regarding an increase in the use of counterfeit passport cards. And FinCEN has the attached notice. And again, you can see there's an asterisk for this item. So you can click on it in the link below to have more info. But what you'll find within there is that, again, FinCEN is providing a lot of great information on how to incorporate this into your own procedures to be able to spot when there is a potential fraudster who's using a fake passport card. And it starts with how they're obtained and how they're used. You can have that background, right? And kind of know what's going through the bad actor's mind and what they're going to be using for this particular scheme. And there's a list of red flags to look out for, right? So ways to spot when you might have somebody who's using this, when you might be able to spot a situation when passports are being used. The trick, of course, being, well, there are valid passports, right? And a passport is a valid form of identification that banks are able to consider for purposes of their BSA and their Know Your Customer and just how you might be identifying your customer base, depending on who you're doing business with. And so included within there to help with that is a whole section on the security features of a passport card. And so FinCEN actually breaks down an example. They have a sample passport card and really hones in on all the security features in there and what to look out for. And, they really are quite complex on how you can use them. There's different aspects of it that you can use to spot when you're going to be reviewing customers that might bring in a passport card and how you can verify that it's legitimate. And of course, as always, they wrap up with SAR instructions. So if you do have a situation where you spot something that might not be legitimate or there's questions as to it that results in you deciding to file a SAR, there's specific instructions to walk through on how to use that. So make sure to take a look at this. Again, the link is in the description below. Go through that. Consider that in light of your BSA procedures. Currently, how you verify passports, currently how you work with your customers, the type of situations that you might be encountering and how to use those red flags to spot them, and then incorporate a review of the security features of the passport for purposes of identifying customers. Next, FinCEN put out this reminder to remain vigilant of environmental crimes. And so we wanted to include this, and actually FinCEN put it out, it was Earth Day recently, right? And so it's a bit of a unique scenario here in the realm of environmental crimes. And when we think about financial crimes, we often think about money laundering, financing of criminal or terrorist activity, embezzlement, and all of those areas. But that's not all. That's not the only type of financial crimes that we'll see. And there can be illicit financing involving wildlife tracking. Right. So maybe the trafficking of wildlife or exotic animals or illegal logging, illegal fishing, mining operations. So this can very much be present and something that FinCEN is reminding financial institutions to remain vigilant of and be aware of. And starts the report by providing that the amounts range between 7 and 23 billion per year. So it's not an insignificant area. There are bad actors and criminal groups out there, and this is a reminder that financial institutions should remain vigilant with information on how to spot this type of activity. So take a look. Again, link can be found in the description below if you want to utilize those resources and understand the type of financial crimes in that sphere as well, and how you can incorporate that into your procedures. And as always, real quick, we are always wanting to keep you updated as FinCEN continues to add to their beneficial ownership, frequently asked questions on their website, and really a whole host of good information out on FinCEN's BOI reporting website. Here we have some new and updated items, which are noted with an April 18th date. As we know, you might have customers who continue to have questions on the rules as it relates to them. The last item then being a trend analysis on elder financial exploitation. And so, again, we all know, those of you on this call understand how serious elder financial abuse is. But FinCEN has issued this analysis, which reports that 27 billion in elder financial exploitation suspicious activity in a 1-year period. So again, very much continues to be a trend on the rise here. We know we see this. We know that you see it on the front lines all the time and are continuing to remain vigilant in this area, continuing to incorporate this, continuing to see how you can better protect your customers from this increase. And we include this, again, just to remind everyone that, those efforts are warranted. that combating elder financial abuse remains a top priority among financial enforcement, both on a federal level, as we're seeing within this report, within this analysis, but also on a state level. DOJ has been putting out a lot of effort into getting education and training out there, and on a legislative level as well, as WBA continues to advocate for tools for banks to better be able to protect their customers. So again, an analysis here. If you're looking for kind of more information, what FinCEN is seeing, what they're doing, but if nothing else, to be aware that the federal and state agencies are aware of this, that we're working together to combat this and looking to find those tools where we can. So with that, I will wrap up these slides and turn it over to Heather.
Super. Thank you, Scott. And I also wanted to quick mention that included in the CFPB items is the most recent supervisory highlights about mortgage servicing. So when you look to the mortgage servicing industry, there's still concerns about the miss of payment of loan payments, not attributing escrow components correctly. So mortgage servicing still continues to be something that the Bureau monitors and watches. And if you are performing mortgage servicing services, you want to make sure that you take a look at that highlights to track what they've identified to make sure that that is not something that you're falling victim to in any way. Mortgage servicing is still definitely a consumer concern as we see payments be unfortunately misapplied through the mortgage loan servicing. So just wanted to make mention of that. It's also included in your materials that are attached with this particular video. But as Scott mentioned, we do have a number of different Department of Labor items to be talking about. And I know that many of you, when you see overtime, you think, well, guys, compliance are different than HR, which is true, but the severity or the breadth of this particular rule, we wanted to make sure it was on your radar because it is it's going to affect every financial institution, both of these topics. But the first one is the overtime rule, issued just last week, effective July 1 of this upcoming year. And we have the bullet points there to kind of give you the nutshell of what it is that is going to be affecting by this particular rule. But in the links below, there's two different links for this particular topic, one to the rule itself and the other one to a resource page put together by Department of Labor, which is actually quite helpful. They've got FAQs on the resource page. They have a small entity guide. So some helpful things to make sure that your HR person is aware of. But when we're talking about overtime pay, we're obviously talking about the Fair Labor Standards Act. And as we know, we have a general requirement that employers are to be paying employees a minimum wage. And for those employees then that work over 40 hours, that person gets their wage plus a premium, an overtime premium, which is basically 1.5 times their current regular pay. We also know that the Fair Labor Standards Act then has exemptions to that minimum wage overtime pay requirement for certain classifications of employees. And the more common one that we see in the financial services industry, financial institutions industry as a whole, is the one for an employee that's employed as a bona fide executive, administrative, or in a professional capacity, which is commonly referred to as the acronym EAP exception, or the white collar exception based upon wearing a white collar to the office, for example. And to meet that exception, there is a test that needs to be met. There's 3 different components to the test. It's the salary basis test, the salary level test, and the employee's job duties test. And we've talked about this many times over the years, primarily when we're talking about the SAFE Act, the mortgage lender compensation. But again, this rule is broader than just a particular segment within the financial industry. But again, you have to meet all 3 of those tests in order for an employee to then be exempt from the standard pay overtime rules. And so what this final rule has done, it has increased the salary level for both the EAP exception as well as the certain highly compensated employees, which is a category by itself within the Fair Fair Labor Standards Act. So the rule resets what that salary minimum is. That salary test first gets adjusted July 1st of this year, and then will be adjusted again January 1st of 2025. And then the rule also sets forth inflation adjustment, where on an effective date every 3 years, that number could very well change based upon what the Department of Labor and Census Bureau labor information is going to be showing as we move forward in time. So that's the first rule, very important rule. It will be in Compliance Journal in the regulatory spotlight section for May, since it just was released last week. So be sure to look for more information on that. The second Department of Labor rule is referred to the rule in a number of different manners. We have it here as the retirement security rule. It might also be referred to as the fiduciary rule. It carries a couple of different names. And so when you're doing your research, just think broadly that it could be called couple different things. But the reason why we're talking about fiduciary is because this is actually changing a definition within the ERISA rules for those who are working with our customers, in particular with our IRA, our retirement customers. This rule was just released last week and has an effective date of September 23rd of this year. So something that's going to be coming down the pike here pretty closely. So what this rule does is it defines who, quote unquote, is an investment advice fiduciary. And it creates kind of a three-pronged definition, meaning that it's somebody who is making an investment recommendation to one of your investment customers. So again, think of it in the IRA setting where you have a deposit customer coming in, they have maybe an IRA CD that is coming due, and they're wanting to know what to do with those funds. And so you may have staff who are meeting with that IRA customer and making a recommendation about what to do with that retirement account. That recommendation that the employee is making may have compensation attached to it. And if it does, such as a commission, then you're going to want to look at this rule to see whether or not this rule is going to impact the bank's business practice right now for making a compensation to an investment person making an investment recommendation. The third component of this, besides being a recommendation of an investment product by an investment person, advisor, and there being a fee, the third prong is that the person, the banker, is holding themselves out as being a trusted advisor, someone who has specifically gained knowledge and is using that knowledge of retirement and of investments in helping the customer making their decision of what to do with their particular IRA or deposit account. So a lot of different defined terms. We're currently working through the rule to see how this rule may have an impact in the bank setting when dealing with your IRA customers and potentially your annuity customers, because those two can be used in this context. So stay tuned for more on this, but wanted to make sure that you were aware that Department of Labor had issued this particular rule here last week. So on the next slide, then, we have a couple of Federal Trade Commission or FTC items that we wanted to make sure that you were aware of. The first one, another alert. Scott said enough with the fraud alerts, but they are important to make sure that your frontline staff know of this. It's always good to hear potentially what your customers might be dealing with to help them be educated to know what's a legitimate inquiry, what is not. It might be something for your marketing teams to be aware of, that they can create some kind of a customer awareness component, whether it be for the website or social media or other types of ways that you reach out to your customers. But the fraudsters, unfortunately, they watch the news too. And what the Federal Trade Commission is saying is, heads up that these fraudsters know that there's phone calls and inquiries out there in the general public about student loan forgiveness. And so, sure enough, these fraudsters are calling students with some information actually that they know about, and claiming to be with Department of Education or other servicers, and they're asking open-ended questions to try to gather information from the customer, unfortunately, and to use that information against them to try to steal someone's identity. So creative, frustrating, but we wanted to make sure that you were aware of this new trend, again, to help make sure that your customers were aware of this new potential fraud scheme. We also wanted to make sure that you were aware of another HR component. Again, it may not be your compliance officer hat, but make sure your HR folks are aware of this. But the Federal Trade Commission issued a rule last week that would ban, or does ban, non-compete clauses within agreements, within terms of employees. And so that's a pretty broad statement. And there are some nuances within the rule, as you can understand. What you want to do is take a look at the rule and kind of break it down to identify a couple different components within your financial institution. What the rule does is, going forward from the effective date of the rule, which is 120 days from the date that it is published within the Federal Register, which has not yet occurred, but is anticipated here to be forthcoming. So upon the effective date of the rule, the financial institutions or any employer would be prohibited from entering into an agreement that has a non-compete component to the agreement going forward. So basically, it bans it. With respect to agreements that are currently in place, the final rule makes those agreements null and void as a general component, although there are some carve-outs to that. And the rule, you're going to want to work through those carve-outs if they are applicable. For those existing non-compete agreements that are in place at the time of the final rule, which become ineffective or unenforceable, there's a notice component that needs to be given to those customers, basically saying the fact that these non-compete components are going to be null and void. Again, some carve-outs to that broad statement, but wanting to give you some broad brushstrokes here of what the rule could be. The rule does provide for certain compete clauses to be okay. So those that are non-solicitation or confidentiality agreements, those could be okay under the rule, but it's very fact-specific, depending upon the actual terms within those agreements of whether or not the terms are such that rope you back into the definition of non-compete. So you're going to want to look at each of those agreements, if you have any, case by case, to determine whether or not it's affected by the rule or is not. There is also a carve-out for senior executives. So the rule does tend to recognize that for some certain individuals, based upon their pay, annual pay, and based upon the fact that they have policy-making decisions as part of their position, that those senior executives could in fact still have some non-compete clauses valid. And so those are all defined terms: the senior executive, the policy-making decision, all within the rule that you're going to want to work through as well. The component that makes it also interesting is that there's also already litigation that's occurring in this particular field. So you're going to want to work closely with your legal counsel if you happen to have any kind of non-compete clause to see whether or not you're affected by the rule, whether or not it would be void upon the effective date of the rule, and how to proceed going forward if we do in fact have certain employees that we want to make sure we keep those components in place. So a lot of information that has come through this particular month, a lot of new law to have to think about, but we wanted to make sure that we got this out to you as soon as possible so you can think through some of these sticky situations going forward here in the next few months. So then we always want to make sure that you also are aware of all the different resources that we have here at the WBA for you. Scott and I every month talk about all the different compliance resources that we create for you. They're all available for you on our website. We have information pieces here for you, the training, the publications. Don't be shy, call us. We're happy to talk through your topic, whether it be a where do I find it question, or just to talk through that you've done your analysis correctly. We're happy to help you with those particular questions. We've also included this time a reminder to get involved. We have 12 different committees and sections that you as a banker in your forte of ag banking or trust banking, mortgage lending, retail, HR, we have a committee for anyone. And check out our website for more information. We'd welcome new volunteers as we are trending to our new fiscal year here in June. And also be an advocate. Scott mentioned this on his conversation about senior financial exploitation. A lot of work has been done and will continue to be done. And be an advocate. Join our team to be an advocacy officer and make sure that your voice is being heard as we go through all of these different new rules that we want to protect those seniors and others as we move forward in our next legislative session. So with that, Scott and I are always happy to help answer your calls. Reach out and we will see you next month. Take care.
See you next time.